I'm going to share the slides. Okay. Now we are going to the next topic, which is talking about the law related to the engineers in society. So in general, first we introduce the Malaysian law. So the law, basically that you have the public law. Public law is basically that to regulate the relationship between the citizen and the state. And this public law can be divided into three, which is constitutional law, administrative law, and criminal law. Constitutional law is regarding about your rights as a citizens. So the main one is the constitution, which is perlembagaan, and you have the administrative law, which is how to govern the country, how to govern the people, and criminal law is that with regards to the crime, what is the punishment for certain crime, and what are the action which is considered as crime. So in Malaysia, most probably that this is the Akta, the Kanun Jenayah or Akta Keseksaan, which is the main law, the main criminal law, besides other laws related to that. Another law is the private law. This is also known as civil law. This is actually to regulate the relationship between citizen with another citizen. Public law is basically that with citizen with the state, with the pemerintah. Ini adalah antara citizen with citizen. So this law, for example, contract law. Contract law is basically the law to govern how a contract being administered between one person to another person or one company to another company. So in the this law, the contract law is quite relevant to the what do you call it, to the engineers. We have tort law, trust law, land law, family law. Family law, most probably that related to the nikah kahwin, cerai, what do you call it, the harta pencarian, sepencarian. And of course, the family law we have in Malaysia, we have two. One is for the Muslims, another one is for non-Muslims. For Muslims, family law falls under Undang-Undang Syariah, Sharia law. And we have the company law, the setting up of the company and whatnot. Those are the laws that govern how the company are being set up and being run. The partnership law, agency, and the commercial law. So most of our discussion focus on these areas, which is contract law, company law, that kind of thing. So in the diagram, we can what do you call it, show in this format. So you have law divided into two, public law and private law. Public law is, you have three division, constitutional law, admin law, and criminal law. Private law, you have contract law, tort, trust, family law, company law, and property law. And contract law, you have laws regarding the insurance, sales of goods, and bill of exchange. What are the sources of laws in Malaysia? The sources of law in Malaysia is the first one is the supreme one is the federal constitution, which is perlembagaan Malaysia, perlembagaan Malaysia. So this laws is the supreme law of the land. Any laws that is inconsistent with this, with the constitution, is null and void. So any laws which go against the federal constitution is invalid, because this is actually the supreme law in this country. The second one is the three constitutions of the states, which comprising the Federation of Malaysia. So, or in Malay, we call it Undang-Undang Tubuh Negeri. This is the constitution for each state, for the 13 states that we have. We call it Undang-Undang Tubuh Negeri. Then we have the federal law, which is the Act of Parliament, Acta or Act that is under federal law. Then the fourth one, we have state laws, which is the laws being enacted in state assemblies by each state. So these laws normally are in the Islamic laws, Sharia laws. So that's why if you what to call it, read the enactment, the state laws is called enactment. It's actually different from one state to another, right? They are not exactly the same. So these are the four sources of laws in Malaysia. Then after that, you have the legislation made by a person or bodies under power conferred by on them by the Act of Parliament. For example, the what do you call it, local council, they have their undang-undang, which got ataupun peraturan. Another one is judicial decision, which is the decision made by the judge become the source of laws in Malaysia. And also another one is that the principle of Islamic laws or English laws suitable to local circumstances. Some of the English laws that we use, the principle of it that we take and use. And another one is the Islamic laws. So we take the Islamic laws and become our laws, especially in the Sharia law, which is enacted by the each states. This is the hierarchy of the Malaysian courts. The highest one, you have the federal courts. Then at the bottom, you have the Court of Appeal. And the courts being divided into two is High Court of Malaya and High Court of Borneo. And under that, you have the Session Court, Magistrate Court, and the Penghulu Courts or Native Courts. Right? So the Federal Court and the Court of Appeal is called a Superior Court. Okay, any questions so far?
No, sir.
No, sir.
No. Okay.
No, sir.
Now, the first laws that is related to the engineers, which is the contract law. This is called the Contract Act 1950. So, in that laws, it spells out what is the contract. What is a contract is what constitutes of a contract, for example. So, what is a contract? Contract is basically that there's the agreement enforceable by law. That is a contract. And there must be two or more parties involved, legally binding between them. And the contract must be built upon an agreement. If there is no agreement, there is no contract. Both parties must agree to the terms and conditions to become a contract. So contract is basically that is an agreement enforceable by law. Second is that there must be two or more parties involved in a legally binding between them. And third, the contract must be built upon an agreement. So these three constitute a contract. Okay. Example of contract: sales and purchase agreement, hire purchase, and any other contract. So those are the examples of contract. Hire purchase, basically when you buy a car, you sign a contract with a bank to take a loan, and you pay monthly installment until you complete your installment. Then the car will come yours. Before that, the car is not yours. The car actually belongs to the bank, is assigned to the bank. Sales and purchase agreements is similar to that also. That you buy the house, then it has a scheduled payment that you need to pay according to the progress completion of the house. So there are many forms of the agreements, of the contract. These are the essential elements of contract. The contract must have these elements. It must to have a proposal and acceptance. You must have somebody to propose, and that person accept your proposal. So that is the first essential elements of a contract. For example, you have a house and you want to sell a house. So you propose, okay, I want to sell this house. And that person, the buyer, the potential buyer say that, yes, I want to buy the house. So there is an acceptance. So you have a proposal to sell and the acceptance to buy. Consideration. What does it mean by consideration? What does it mean by consideration? Consideration is basically that the amount that you are willing to pay for that transaction. For example, I want to sell a house for 1 million, and that person said, okay, I agree to buy at 900,000. So that, or even they say that, okay, I'm willing to buy at 1 million. So that transaction must have a consideration, a value. So for example, the buyer said, okay, I don't want to buy at 1 million, I want to buy at 900,000. And the proposal said, the guy who wants to sell said, okay, I agree. So the consideration is 900,000. That is the consideration. That's what it means by consideration. Is the money or the value attached to that proposal, attached to that contract. So that's why if you want to sign a contract, at least the consideration of $1 or 1 ringgit. You must have that consideration to make it valid. The third essential element is the intention to create legal relation. That you want to have it to be legally binding. You want to have it whether it's a written contract or verbal contract, that it must be legal. It has to be a legal relation. And the fourth one is that the certainty. Is that the, what do you call it? The contract must be certain of the terms and condition. What are the terms and condition? For example, what are the specification of the house that you want to sell, and what is the amount of money that you want to pay, and for how long is the contract? When is the house to be delivered, for example? So the contract must be certain. And legal. The next one is legal capacity. The person that wants to be binded by this legal relationship must be legally has the what do you call it, the uh, the capacity to enter into this contract legally. So basically, for example, the house is not a stolen house, it's not a stolen property that is legally belongs to him. Yeah? So must have a legal capacity. Yeah? So that's what it means by legal capacity. The next one is the free consent. The contract must be done willingly. There is no forcing of entering into a contract. Tak boleh paksa. It has to be free will. So without free will, without the free consent, the contract is not valid. For example, somebody force you to sign an agreement. So that agreement that you sign is not valid if somebody forcing you. You must sign willingly. Legality of the objects. Legality of the object is that the object that you want to buy, for example, must be legal. You cannot have a contract for selling and buying drugs. Cannot. You cannot have a contract for prostitution. It's illegal. Prostitution is illegal. Therefore, the contract is also illegal. So anything that is illegal, the object is illegal, or the transaction is illegal, you cannot have a valid contract. And the last one is required formalities. It has to be written, for example, it has to be witnesses, those kind of things. So it has properly signed and stamped. So there is required formalities. These are the 2, 4, 6, 8 essential elements of contract. So sometimes in the exam, we'll ask you, what are the essential elements of contract? And explain. So these are actually some of the favorite questions that we ask. So in the Contract Act 1950, this is actually the law regulating contracts in Malaysia is governed by this and revised in 1974. What is the objective of the Act? The objective of the Act is to protect the legal rights of all parties involved in the contract agreement. It protects the right of the seller, also protect the right of the buyer, for example. And it to regulate the practice of contract management. It creates a regulation for the contract management. What can be done, what cannot be done, what can be contracted, what cannot be contracted. Right? So this is actually the consideration that I mentioned just now. The consideration or object of an agreement is lawful unless it is forbidden by the law. The consideration must be lawful. Money must be lawfully acquired. For example, the house that you want to sell must be legally owned. So it's forbidden by law. If it's forbidden by law, then it is not cannot be a consideration. You cannot pay using drugs, for example. It is of such a nature that if permitted, it would defeat any laws. So consideration cannot be an object which will contravene other laws. If it's fraudulent, then it's not consideration. It involves or implies injury to the person or property of others, cannot be a consideration. And if the court regards it as immoral or opposed to public policy, that also cannot be a consideration. So every agreement of which the object or consideration is unlawful is null and void. So consideration must be lawful. What is a contingent contract? It's a contract on something possible but not certain to happen. So this is a type of contract. So a contingent contract is like insurance. Insurance is actually a form of contingent contract. So it's a contract with regards to something which is possibly happen, but you are not certain this thing will happen. For example, you have a contract for with an insurance company to pay you 1 million if your house is burnt. So that is a contingent contract. So to do or not to do anything if an uncertain future event happens cannot be enforced by laws unless and until that event has happened. So basically that if the house is not burnt, basically that whatever that you pay to the insurance company is non-returnable, for example, is burnt. And the insurance company are not obligated to pay you because the house is not burnt. So a contract to pay B 10,000 if B's house is burnt. If the event becomes impossible, such contract becomes void. If let's say B agrees to pay 1,000 if B marries A's daughter C. C was dead at the time of the agreement. So the agreement is null and void. How can A give his daughter C to marry B when C is dead already? So that is impossible to happen. So that contract is considered void. So this is the type of the contingent contract. Another type is contract of indemnity. It's a contract by which party promised to save the other from loss causes to him by the conduct of the promisor himself or by the conduct of any other person. Agreement which stated before something is being done. For example, a contract to indemnify B against the consequences of any proceeding which C may take against B in respect of a certain sum for example, is 200 ringgit. For example, this. Let's say a contract B signed with C. B signed with C, and if anything happened, let's say B did something wrong or whatever, that through this contract that you are in that B will not pay you, but the other company, let's say, pay you 200 ringgit, for example, or 1,000. So that is the to indemnify B from the losses. So a contract by which one party promised to save the other from loss causes to him by the conduct of the promisor himself or by the conduct of any other person. This is really example is that, for example, you buy the insurance, the car insurance, accident insurance, that you have a car, okay, and you buy a contract, what do you call it, an insurance, accident insurance. Let's say if you involved in the accident, that you have to pay the person that yang you langgar. Katalah you bawa kereta, you langgar, and you have the insurance. So the insurance company actually will pay for the damages that you cause. So that is actually contract of indemnity. Clear? Faham?
Faham, sir.
Faham je.
Okay.
Faham, sir.
So, what time is it now?
10:45, sir.
Kat pukul 11 kan? Kat pukul 11.
Yes, sir.
Okay. So, legal liability. What is liability? Liability is something that one owes an obligation or debt. So that is the liability. That's the meaning of liability. It's a debt or something that you owe somebody. Tort is actually any wrongful act that does not involve a breach of contract and for which civil suit can be brought. So basically, tort is an act which is wrongful, but it does not involve the breach of the contract. But this wrongful act actually can be brought to court as a civil suit. So that is the meaning of tort. Negligence. Negligence means that you are not following reasonable rules and standards that apply and committed a wrongful act. So there is a certain rules that you need to apply, but you are not following this rule or standard and commit this considered as commit a wrongful act. So that is negligence. Negligence ni macam cuai. So that is negligence. So act, the negligence is actually an act is defined by legally negligent if the following four items is true. So this is called legally negligent, which is the manufacturer. The first one, the manufacturer has a duty to follow reasonable standards and rules. So if the manufacturer must follow a standard and rules, there is one of the factor for the legally negligent. Second, there must be a breach of duty or fail to include safety devices, for example. So there was a breach of duty, basically that you don't follow the rule. So there must be a rule and there is a breach of the duty of the rule. And the third, somebody is harmed with respect to that breach. And fourth, the breach actually causes the harm to the plaintiff. So if these four factors exist, Therefore, it is called a legally negligent. Let's say you buy electrical device, appliance. Okay, so this electrical what do you call it appliance must follow the safety standard set by SIRIM, for example. Okay, so item one, actually there is a rule or standards that need to follow, which is the set by SIRIM. And this manufacturer actually did not follow that standards. So there is a breach of the rule, breach of duty, because the manufacturer did not follow. And you as a buyer, just happened that when you use that equipment, you got burnt. Terbakar lengan. Okay. So it's complied to the third factor, which is the plaintiff was harmed. You were harmed. Your hand got burnt. And you burn your hand is because you use the equipment that you bought, which does not follow the standards that it's supposed to follow. So the breach, the manufacturer did not follow that standard, cause the device to fail and to harm you. So if you have all those four elements, therefore you can sue the company for negligence. Without these four conditions, you'll not be able to meet the requirement, the definition of legally negligent. If you sue in the court, see, most probably that you will lose. Okay. Clear on the definition of legally negligent. Clear? So this is four factors to determine whether a certain subject is legally negligent or not. Another term is that the strict liability. And even less stringent standard known as strict liability. So basically that legally negligent just now is a very, they set a high requirement in order to meet that. But a less stringent standard, which is called a strict liability. And most probably that we adopt this strict liability. So what does it mean by the strict liability? The person or the company suing you does not have to prove negligence. Basically that it does not have to prove negligence. It does not have to prove those four items just now that we mentioned in the legally negligent. Basically, you are liable if the following four things hold true. If these four things hold true, then therefore you are liable. The first one, the product was dangerous or defective. It doesn't have the standards to follow. It's just that the product that you produce is dangerous or defective. You have some defect. And this defect exists when the product actually left your control. Basically that the defect actually exists when it reaches your store. And this defect cause harm. And the harm is assignable to the defect. So if this fourth thing holds true, therefore you are liable for strict liability. You are liable. Let's say you produce a what do you call it? blender. Okay, you produce a blender, and this blender has a defect in it. Maybe the blade actually was not screwed properly. And this defective blender actually exists in your premise. So you pack and you send to the buyer. And the buyer use this blender. And the blade flew out from the blender and cut the person on the face. So that defect actually caused the cut on the face. And that cut actually can be assigned to, yes, it was caused by the blade of the defective blender. So these four holds true, therefore the company, you can sue the company for strict liability. Okay. So now, if I ask you to compare between the legally negligent and strict liability, can you do that in an exam? Compare and contrast between the legally negligent and strict liability. So basically that you need to compare those four things. What does it mean by legally negligent? And what does it mean by strict liability? So you discuss on how, on why, on which one is actually more stringent, and which one is more difficult to prove in court. So you should be able to do that in an exam. So liability and negligence. Negligence, all parties may be held liable if reasonable care was not observed in producing or selling the product. So all parties will be liable if they meet all those four conditions in legally negligence. Right? For strict liability, manufacturer's known or knowable defect gets into the market, injury happens, injury results from a product defect, defective product delivered by the manufacturer. So this is actually the manufacturer is liable, whether they know that product, that defective product went into the market or not. As long as there is injury happen and injury result from the product, the defective product that they sell, and that defective product actually delivered by the manufacturer. It does not matter whether they know that product is defective or not. So they are still liable. Right? Absolute liability, basically that the manufacturers not warning of product danger, even though the danger was scientifically unknown at the time of production and sales of the product. So the manufacturer is still liable. Absolute liability. If the manufacturer did not put any warning that the product is dangerous, even though at the time it was not proven that the product is dangerous. That is absolute liability. So negligence is basically that you have the standards and you don't follow the standards, and you meet all those requirements, all those factors, then you are negligent. The strict liability is that you don't know. Whether you know or you don't know the product is defective, But if injury happened and that injury resulted from your product and you actually the one who deliver that product, then you are liable, strictly liable. For absolute liability, that even though if you don't know that product is dangerous and it's not even proven that it's even dangerous, but if you don't give a warning and if something happens, you are absolute liable. So those are the three levels of liability and negligence. So the most strict one is negligence, and the loose, a bit loose is a strict liability, and the most the is the absolute liability. Is the paling mudah sekali. Even if you don't know the danger, also you can get sued on absolute liability. Okay, clear so far?
Clear.
Okay. So you so far you can digest all those?
Yes.
You can digest. So you want still to continue some more? Tak nak dah. Dah cukup dah untuk for today.
Cukup Azhar.
All of you got enough for today,
Cukup Azhar.
Okay. So okay, we stop here for today. So just go through the slides, and also the important thing is that you look at these what do you call it, this assignments, and work on it, work on the assignment, right? So if you have any question, you just send message to me through WhatsApp or through email, right? If you have any question. But before that, for next week, you look at the slides that I put in for A, for B, for C, for D, for E, I think. You study that first, so that during the online lecture, I can just skip some of them, right? You just ask question which is relevant for this. You can just what do you call it? Seek clarification, on the items which you don't what do you call it? Which you are not clear or you don't understand. Okay. So now it's 11 o'clock. So we can stop here, right? And any question before we stop? No, all clear. Om ngantuk.
Clear, sir.
Clear. Okay. Thank you for your attention, for your attendance. I have 22, so perhaps 21. Muhammad Amili ada? Tak ada.
Ada sir.
Ya. Ha?
Ada.
Amili ada?
Saya sir, saya.
Mana? Kejap, saya tengok mana ada Amili dalam ni kan. Dalam senarai ada. Ada, okey. Okey. Muhammad Ridwan Hashim Halim. Ada tak?
Ada sir.
Mana? Muhammad Ridwan. Saya cari nama dalam senarai. Muhammad Ridwan. Tak ada pun. Muhammad Ridwan. Tak ada. Okey. Ainul Fitri. Tak ada. Nur Fazlihi. Ha?
Ada, Fazli ada.
Fazli ada.
Ya.
Okay. Okay. Fitri Zuhairi ada kan?
Ada sir.
Okay, masuk lewat ni. Ainul Fitri ada? Ainul Fitri tak ada?
Ada sir.
Ada? Tak ada nama pun. Saya check. Ada. Okay, mana ni? Mana tadi? Dalam mata saya kurang nampak. Mana dah tadi? Hilang dah pula nama. Okay. Akmal Nur Hakim. Tak ada. Well, Hakim tak ada. Redwan Halim ada?
Ada sir.
Ada. Okey, baru nampak. Syazwan Rosli?
Ada sir.
Ada, okey. Okey. So yang tak ada basically seorang lah. Akmal Nur Hakim. So okay, kalau tak ada soalan, we can stop here and we meet next week.
Alright sir.
So selamat berpuasa dan jaga diri elok-elok this MCO PKP.
Baik sir.
Thank you. Assalamualaikum.
Assalamualaikum sir.
Thank you sir.
Okay, bye. Bye.
Thank you sir. Thank you sir.
Okay. Bye. Saya stop.
Bye sir.